irrelevant.
Well, I don't see how whether or not he had any drugs, legal or illegal, goes to his credibility.
Your Honor, if he had marijuana or some sort of drugs that affect his memory, it's certainly relevant.
Well, I don't think it matters if it's legal or illegal. If he was
Okay, I mean-
under the influence or intoxicated to the point where he couldn't remember.
Right.
Or if it was blurry, that's different, but I don't think.
I'm sorry, I didn't say it legal or illegal, just to jog people's minds on the sort of things I'm asking about. Had you had any alcohol that
Earlier that day,
day? Okay, and when you say earlier that day, around what time?
7 o'clock.
That's 7 p.m.?
Yeah.
Okay, and what did you have to drink?
I think it was 2 beers, 2 Coronas.
Around 7 p.m.
And had you had any drugs that day?
I'm gonna object this to overly broad. If the question is whether, well, the intended purpose of these questions is to determine whether or not this witness's memory was altered in any way. Well, to ask about what drugs this person would have taken is overly broad.
That also won't help me determine it. Unless there's an expert coming in to say whether or not the drug use would have affected his ability at the time that it happened. Either he was clear, and because he's the only one testifying to what you're asking about.
Right.
So either he had a clear mind and he can observe what happened or he didn't. Doesn't matter what the drug is.
Your Honor, I can ask him specific questions about what drugs he had. We're creating a record here, right? And you're to determine his credibility and whether or not his memory is affected. It's certainly relevant if he had any drugs that day that would affect his memory.
That's the question to ask.
Okay. Did you have any drugs that day that would affect your memory?
No.
Okay, did you have any marijuana that day?
Objection, that's just, she's asked if there be any, if he had taken any drugs that would affect his memory.
He said no.
Your Honor, this is cross-examination. I can ask him specific questions about things that he did, and if he doesn't think that marijuana affects his memory, then that's something I can impeach him on.
Impeach him based off of what?
The fact that marijuana does affect the memory, and that's a well-known fact that I can ask for judicial notice of.
I wouldn't give you judicial notice on that because everyone,
Your Honor,
let me finish. Everyone who intakes marijuana, it affects them differently. So the questions you're asking him are based off of his own, what he believes, not what I believe. I can't tell you whether or not him smoking marijuana at 7 a.m. was affecting him at night. That's not, I can't take judicial notice of whether or not he was still, if he was high or not. So for that questioning, it would be irrelevant because I can't answer or give I don't have a medical opinion to give on whether or not he would be able to see or observe.
Your Honor, just to briefly respond, it's still a fact that you can consider when you're determining probable cause and credibility.
And he answered he was not taking any drugs. Marijuana is a drug, right? Do you all agree?
Yes, Judge.
Okay, and he said no. Am I wrong or am I right? You say no?
You did, that's correct.
Okay.
Okay, and so you testified that you were in the car down the street from, you said your house?
No, it's my mom's house.
Your mom's house.
It was a house down. I wasn't down the street, it's a house down.
Okay, and so you were not right in front of your house, correct?
No,
You were in front of the field that's there.
yes, because there was a car in front where he was parked. My cousin's car was parked in front. So for him to get out, I had to do right there.
Okay, but just for the record going forward, just answer the question that I asked, okay? Thank you. And so,
And you have object to being argumentative, the witness was answering the defense counsel's question.
Your Honor, he was giving additional information. I mean, I think it's fine right here, but I can instruct the witness.
I will. Mr. Tips. Just make sure you answer the question, okay? If you have difficulty understanding it, you can always ask again. I don't understand the question, or it needs to be fair. This is cross-examination, so it's a little different than a direct thing. Best answer to your best ability is this objection. As you've been doing on the floor, just wait to answer the question, okay?
Thank you. And so you were indicating that you were sitting in the car, is that correct? Okay, and how long were you sitting in the car before the conversation started with the one guy? And you indicated that you saw the vehicle, you saw there was another vehicle in front of in front of the house across from you, correct?
Um,
Okay, so there are two, you're in a vehicle, right? And you testified that you saw another vehicle that was an Explorer or another kind of SUV, correct?
across the street, right at the side, yes.
Right, okay, so your vehicle was parked opposite of, of 6286 Penrod, is that correct?
I don't know if that's the address.
Okay. What, address, I guess, were you parked in front of, you don't know?
There's no house there.
Okay, so it's a field. And you don't know what the address is of the house that's across the street from that field? Okay, but there was an SUV parked in front of that house, correct?
Yeah.
And you indicated that your vehicle was pointing one way and that vehicle was pointing the other way, correct? And so are you both parked parallel to the houses there then?
Yeah.
Okay, and the other vehicle, this SUV Explorer or something else, that vehicle then, you observed it back into the driveway of that house?
You know, he reversed, he pulled in front of me, then he back.
Okay, and,
You say he did that.
The big one.
the big guy? Okay, and so you saw the big guy move the car, and then at that point, he came out and spoke to you?
We got a car.
Yeah.
Yeah.
Okay, and, while that was happening, you indicated that another individual with light skin, he's the one who shot at you? And where was that person?
On like the side and between the cars.
The side of the house?
Yeah, like on the grass, like the side of the house.
On the grass, so there's two houses, right? And so he is in between those two houses in the grass?
In the driveway, he on the passenger side of the car, but he like at the back, at like the corner of the house.
Okay. So he's back towards the house, and your car is in the street, across the street from where he is, right?
Yeah.
Okay. And there's a driveway, right? So he's near the house, and then there's a driveway that extends,
Uh-huh.
and then there's the street, and then there's your car, right?
Yes.
Okay. And so the big dude, he comes out to talk to you?
No, he didn't come out to talk to me. He was saying something. I didn't even know he was talking to me.
Okay, so you see him
Uh-huh.
standing somewhere,
Yeah.
and then you, eventually you realize he's talking to you. Where do you see him standing?
He was like in the driveway, like turned towards the car.
In the driveway, on the driver's side of the car?
Yeah,
Okay, and he's turned towards the car?
yeah, but he in front of the car.
Okay,
Like,
so he's in front of the car with his back,
Like, yeah.
his back to you?
No,
So he's,
he was talking, like I'm talking to you, that's how he was talking. to me.
okay, so his
From
back
across the street.
is to his car?
Yeah.
Okay, and then he's talking to you? And, you indicated that, so then it was at that point that you started hearing shots fired? So you indicated that the big dude was talking to you, he was standing in front of his vehicle, correct?
Yeah,
And then you heard shots fired?
after I said what I said.
Okay, so there was a conversation, the big dude is still standing in front of the car, right? And shots came from a different person who was back by the house, correct?
At the passenger side of the car. He was
Okay.
in the back of the house.
Okay. And you indicated that, that you, also had a weapon in your car?
Yeah,
And what kind of weapon was that?
Glock.
It was a Glock handgun?
Just so that the record is clear, I'm just gonna ask if it was clarify what you used, but
Yeah,
And so yes, you said you had a Glock in your vehicle and that you shot back, you fired your gun, correct?
after they shot.
Okay, and, you shot your gun towards the big guy though, right?
I shot towards both of them. I
Okay.
was trying to shoot both of them.
But you know that you hit the big guy, right? You
Yeah,
hit the big
yeah.
guy. And you indicated that you shot 10 times, correct? And you never got out of your vehicle? And you indicated you were in the driver's seat, correct? Okay. How long would you say this whole incident took?
It was so fast.
You said it was so
It was
fast?
so fast, I can't even tell you how long it took. It happened so fast, I can't tell you how long it took.
Do you think just a few minutes, something longer than that?
Objection, the witness has already stated, it happened so fast, I couldn't tell you how long it took.
I'm gonna allow it just to narrow it down, 10 minutes, 5 minutes, some type of range.
It was probably like maybe
10 minutes? And that's from the time that you pulled up to the time that you pulled away? Okay. And you, after you were shot and you returned fire, at some point you drove away, correct?
Yeah.
Okay. And was that right after you finished shooting, or were you still shooting when you drove away?
No, I wouldn't shoot.
So you finished
I
shooting,
didn't have no more bullets.
you ran out of bullets? Okay. And then you drove off when you ran out of bullets, correct?
Yes,
And you went to a gas station, yeah, correct?
yes, ma'am.
So you have indicated that there were two people, one you referred to as the bigger guy, one the light skinned guy, is that correct?
Yeah.
Okay. When you say that, you know what, I'm gonna check that. I don't have any further questions, Judge.
All right, so you said you were shot during this incident, right?
Yes, sir.
All right, and it was your testimony of the light-skinned guy doing the shooting.
Yes, sir.
All right, about how far away from you, sitting in the car, was the light-skinned guy? How many car lengths?
It was probably like from here to that wall.
All right. So you would say maybe 3 car lengths? All right. You said it was a dark night, right?
Yes.
How about the street lights? Any street lights, any lights coming out from the houses, any ambient light?
It was two porch lights on over there, and it was right on that thing out at the house.
Right. You would say they were in front of those lights, though. Those lights were behind them, correct?
They was on the side, like on the houses. On the side.
Okay, okay, some lights on the side where people were shooting at you, correct? All right, so listen to the question and think about it. This is not a race, quick to answer, all right? When you started shooting, all right? What I'm trying to understand is, you got shot. When did you start shooting before you got shot, when you saw a gun getting pulled out at you, after you got shot, or sort of all at the same time? Your testimony was this all went down fast.
No, when I got shot, I was shooting back, but I had already been shot.
You were shot multiple times.
Yeah,
All right, you were shot in the leg, in the back, correct?
both legs.
All right. Any idea of what injury you received first?
Right, my left leg. My back was the left. I was pulling up.
All right, so you were inside the car the whole time, correct?
Yes,
So these bullets would have had to hit the car, go through the car, and then affect you, right?
right.
And I'm gonna, just to clarify, so it's your testimony, you were shot, you believe it was the leg first, correct?
Yes, I believe it was.
And then when did you start shooting?
After I was shot.
Your buddy that was in the car with you, he have a gun?
No,
Do you have any extra ammunition in the car?
no,
Just had the one clip in the Glock.
yes, sir.
How many rounds does that clip hold?
No, 15, plus one in the head.
Did you hit anything when you started to return fire?
The big one.
Now, the light-skinned guy, the big dude, I'm trying to understand in my mind who was farther behind,
The last season.
all right? Was the big guy in his line of fire when the fire was directed towards your vehicle?
Yeah, so he was in front of the car, so it wasn't him.
All right, well, you first said he was in the line of fire. Is that incorrect?
By line of fire, what do you mean?
From the light-skinned guy, was the big guy in front of him in the direction of your vehicle?
No, he wasn't in front of him. If he was in front of him, he would have shot him. He was on the side of him.
Where did you drive off to?
I drove on Warren, I made a right. CR438, Warren Everett.
All right, I don't have any further questions.
Have you ever seen these two individuals before?
I only saw the victim.
Okay. And have you ever had any beef with either of the two defendants before?
No, no words.
Was this shooting all a surprise to you?
Yeah,
Here, I have the next one. Did you see anybody else in the SUV?
Objection outside of the scope of my redirect.
Okay.
At this time, you're ready to call Chanel Lewis to the stand.
Your Honor, isn't that the witness that we're waiting for the attorney for, or is that the other? He's here.
Ready, Mike, and before you sit down, I'm going to have Attorney Dillard on the record, okay? Raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth. Yes. Okay. You can have a seat for now, and Attorney Dillard's going to say something, and then, the prosecutor can ask you. Right. It's close, yeah, close. Okay, and Attorney Dillard, can you place your name on the record, please?
Record Joseph Dillard, P. 37225. On behalf of Ms. Lewis.
Okay, and Ms. Lewis has you as an appointed attorney based on her request to have counsel. I guess I should let you speak. What is your involvement with this case?
Witness representation.
Okay, can you counsel Ms. Lewis?
Yes, Your Honor, I advise Ms. Lewis of constitutional rights, including the right to an attorney, the right to remain silent. If she chose not to testify, that she has the right to get self-determination. I've also informed her of further, and that she's, anything she says can be.
Does that sound accurate?
Yes.
Okay. Attorney Dillard, thank you. I just want to place that on the record.
Thank you, Your Honor. I'll stick around.
Okay. And Ms. Nassif, you have your record. Thank you.
Good afternoon, Ms. Lewis. Hi, I'm gonna ask you to speak into the microphone. You've got a really soft voice, so I'm gonna ask that you speak into the microphone. You can even lower it so it'll meet you. This one? Yeah, that one. It's in your lap. Okay. Thank you, Ms. Lewis. I'm going to take you back to December 19th of 2022. Have you gone to 7286 Penrod or the street of Penrod in the city of Detroit, County, Wayne, state of Michigan?
Yes.
All right. Were you in a vehicle?
Yes.
Who were you in a vehicle with?
Beyonce,
Can you give me last name?
Jackson,
Okay.
and Jordan Davis,
Okay.
India Jackson.
India Jackson?
Yeah.
Okay. All right. Now, how do you know these three individuals? How do you know Keontae Jackson?
That's India's boyfriend.
Okay. And how do you know Jordan Davison?
That's a mutual friend.
Mutual friend?
Yes.
Okay. And who is India to you?
My cousin.
Okay, India's your cousin. All right. Do you see Keontae Jackson in the courtroom?
Yes.
Can you tell me where Keontae Jackson is in the courtroom? Let the record reflect that the witness has identified the defendant, Keontae Jackson. So reflected. Thank you. Do you see Jordan Davison in the courtroom?
Yeah.
Can you tell me where Jordan Davison is in the courtroom and what that person's wearing?
The right side of Keontae Jackson behind you.
Okay, let the record reflect that the witness has identified Jordan Davison.
If I could just ask for them to indicate the piece of clothing, I just think the right and the left are that's kind of a easy indication.
That's fine, that's fair. Can you describe an item of clothing that Jordan Davison is wearing?
I'm sorry, can you say it again, please?
Can you identify an item of clothing, maybe even color, that'll help that Jordan Davison is wearing?
Green.
Okay, let the record reflect that the witness has identified Jordan Davison. So reflect. And, all right, and can you describe the type of vehicle you were in on that day?
Ford Explorer.
Ford Explorer,
Yeah.
okay. Do you recall the color?
It's a dark color, so I don't actually remember.
That's fine. All right. Where were
you seated in the vehicle?
Behind the passenger seat.
Okay. Who was seated next to you in the back seat?
Brother Davidson.
Okay. And who was in the front seat in front of you in the front passenger seat?
Aliyah.
Okay. And who was driving? Okay.
To which location, to the hospital or the house?
No, to the house. Thank you for that clarification.
Keontae Jerome.
Okay. All right. And did you see Keontae interact or talk to anyone outside of the vehicle you were in?
No.
Okay. Did you hear him speak to anyone? No? You're shaking your head?
No.
Okay. Did you see Jordan Davison interact or speak with anyone outside of your vehicle?
No.
All right. And when you were driving to the vehicle, did you ever observe any weapons in the vehicle?
When I drove to the vehicle.
Well, let me rephrase that. I'm sorry, that was a bad question. When you drove to the house and you were in the vehicle and you were in the rear passenger side, did you observe any weapons in that vehicle?
Yes.
Where was that weapon?
Front area.
Okay, when you say front area, where in the front?
Between the driver's seat or the passenger side.
Between the driver's seat and passenger side?
Yes, somewhere in the front.
Okay. And can you describe that gun? Or strike that? Can you describe what that was?
Can I describe it?
Yeah. Do you recall giving a statement to Detective Edward Lehman?
Yes, I recall, but I can't. Or the gun.
Well, describe it. You don't have to tell me what make or model.
It's difficult. I just know it's black and it's just not a handgun. Other than that, I don't.
It was not a handgun?
It wasn't a handgun.
Okay, so was it a longer gun?
Yes, somewhat like that, yes.
Okay, all right. And was this gun, you stated was between the driver's side and the passenger side of the vehicle?
Yes.
Was Keontae at the time driving when that gun was in the front side of the vehicle?
Yes, he was.
All right. And did you observe Keontae exit that vehicle when he got to that Penrod location?
Didn't need exactly.
All right. Did you see Keontae pull into the driveway? Yes? All right. And did you see where Keontae went when he pulled into the driveway?
When he put into the driveway, he just got the clothes out and went to the inside the house.
Okay. Where did he get clothes? Let me stop you there. Thank you, though. He got clothes out. Where did he get clothes out from?
The trunk.
Okay, the trunk of the vehicle you all were in?
Yes.
All right. And did he go into the house with those clothes?
I want to say he did. I wasn't paying attention, honestly.
Okay, that's fine. Did you hear him speak to anyone?
I didn't
Objection,
even.
asked and
No.
answered. She asked him that, she asked you that. She's in.
Okay.
Adrian says, did you have a response or?
No, I don't. I'm moving on. Thank you, Judge. Did you observe that gun be taken out of the vehicle?
No.
Did you observe someone give that gun to anyone?
No.
Do you recall giving a statement to Detective Edward Lehman?
Yes, I do.
All right. And Your Honor, may I have a moment?
Yes.
to the witness. Ms. Lewis, do you recognize this document I'm handing you?
Yes, I do.
All right, and I'm gonna turn to, there are 3 pages. At the bottom of this 3rd page, is that your signature?
Yes.
All right, and is that, did you date it and time it?
Yes.
All right, and did you give this, so you gave this statement on December 19th, 2022?
Yes.
All right, would it be fair to say that you had a clear recollection of what had occurred the night before or earlier when you gave the statement? When you gave the statement, did you have a clear recollection of what had happened on that Penrod Street?
I gave what was fresh on my mind at the moment.
Okay, so it's fresh in your mind at the moment, all right? And I'm gonna have you review your statement. I'm gonna ask you again about that weapon and who had that weapon or where that weapon went on that day. Okay, do you have are you done reviewing your statement? All right, do you recall being asked, can you describe the gun and answering a long gun with a scope on it and a banana clip?
Your Honor, I'm gonna object to, she's reading her statement, and if she wants to impeach her with it, I mean, this reading it in like this, she needs to first establish what the testimony was today, whether or not she remembers this, she can't just read the statement.
Your Honor, I am impeaching the witness. I have already asked the witness about describing the gun, and she already stated she couldn't remember. When I got her to expand more, she explained that it was longer than a handgun.
Well, you can ask her to refresh her recollection, she said she doesn't remember, and she gave what she could remember today. That's not a problem.
You said it's not appropriate.
I said it's not a proper impeachment.
I don't think you have to refresh your recollection first.
But she did, she already asked her, she's trying to say that she said she didn't remember today, right?
Okay.
So she'd have to establish that these statements were made and that what she's saying now is different. She, again, she asked her what she remembered and she said it. So if she's trying to say she didn't say that to the police, then that's an impeachment, it's not what she's saying.
I think for her to even get to the impeachment, she has to say what part of the statement is inconsistent with the testimony today. I don't know how she can establish that without reading the statement, the part that contradicts her statement.
Thank you, Judge.
Now, ma'am, I'm gonna ask you again, were you asked to describe the gun?
Yes.
All right, and did you answer that it was a long gun with a scope on it and a banana clip and it was all black?
Yeah.
All right, and now I'm gonna ask you, do you know, you refer to someone as ICE in this statement, do you recall who you were referring to when when you're referring to ICE?
Yes.
Who is that?
Jordan Davis.
Okay, thank you. Now, I asked you if you knew if that gun had been used or if it had gone anywhere, and you said you don't remember. Is that true?
Yes.
All right. Do you recall? One moment, Judge. I want to be very specific. Did you recall being asked when the argument started, who grabbed the gun? I do recall being asked that question. Okay. And do you recall answering, it was already grabbed by Keontae before the argument started? Keontae gave the gun to ICE and told them to hold it in case anything happened.
Yes.
Okay. Did you see anyone shooting that gun? Who was shooting that gun?
Jordan Davis.
Thank you. Do you know where ICE put that gun after he was done shooting?
I don't know.
Okay. Did you see where Jordan Davison and Keontae Jackson went after they were done shooting?
They ran towards the back.
The back of what?
The back of the house.
Okay.
Can I clarify? You said they
I
were
will,
done shooting.
I will clarify, sorry,
Okay.
Judge. When both, I will clarify. Did you see where Jordan Davison and Keontae Jackson went after Jordan Davison was done shooting?
Towards the back of the house.
Thank you. And did either Jordan Davison or Keontae Jackson have the gun with them when they returned?
Not that I recall, no, I wasn't paying attention.
Okay. Can I have a moment, Your Honor?
Yes.
I have nothing further at this time, Judge.
Cross, the judge, I get, maybe, you can turn your box to the top.
Okay, good afternoon, Ms. Lewis. I'm gonna ask you some questions. If you don't understand my question, will you ask me to rephrase? Is that fair? Okay. So you testified that it was nighttime when this happened, is that correct?
Yes.
And you were in a vehicle with your cousin India, Mr. Jackson, and Mr. Davison, correct?
Yes.
And you arrived at Mr. Jackson's house, correct?
Yes.
And that was the house on Penn Road?
Yes.
And you testified that you were sitting in the vehicle
Yes.
and Mr. Jackson got out of the vehicle with some clothing, correct?
Yes.
Okay. And at some point you testified that that you heard some shots fired, is that correct?
Yes.
Okay. And you indicated that you saw Mr. Davison fire those shots.
I'm sorry?
You indicated that you saw Mr. Davison fire those shots?
Yes.
Okay. And did you see anybody else fire any shots?
Yes.
Who else did you see fire shots?
Back from the street.
Okay, so there was somebody across the street, right?
Yes.
And they were in a vehicle?
Yes.
Okay, and so you're indicating that you saw somebody shooting from that vehicle?
Yes.
And where they were shooting from the driver's side?
Yes, I want to say yes.
Okay, when you say when you want to say yes, is that you're not totally sure where they came from?
Yeah, yes.
Okay,
They were shooting coming from the car for sure. I wasn't, I ducked.
okay, so you heard shots and you ducked? Okay. And so as far as what you actually saw, you indicated you saw Mr. Jackson firing, and you heard shots, or did you see light flashing coming from the car or anything like that in relation to the shots fired?
Oh, no, Mr. Jackson, just shoot it.
I'm sorry, Mr. Davison.
Yes.
Okay, so you saw Mr. Davison shooting. Where was he shooting from?
Front of the vehicle?
Okay, and, your tone makes me think are you sure that that's where you saw him shooting from?
It was in front of the vehicle, for
Okay.
sure.
And, the other vehicle, you indicated that you thought shots were coming from there too, correct?
Yes,
And is that, and so you observed something coming from the vehicle?
yes,
Okay, so you saw like the actual shots or the bright light shooting?
yes.
About how many shots do you recall hearing?
I don't know exactly. I don't know.
Okay, like 5, 10, 20?
I would say at least around 5, not for sure, not 20, but yeah.
Okay, not 20, more than 5. Okay. And does that include the shots coming from both sides?
Yes,
Okay, did you see who shot first?
I see who shot first. The
Yeah.
guy across the street.
The guy across the street shot first.
Yes.
And did you see where they were shooting? Is that something you could see?
Well, I didn't see what they were shooting, but I know they were shooting at them in the front of the car.
Did you,
Other than that-
I'm sorry, go ahead.
Other than that, no. I just know that they were shooting at these two.
Did you see the gun at all?
His gun, yes. He had his up towards the window.
When you say his gun, you mean the driver of the other vehicle?
Yes.
Okay. And tell me again, sorry, you were gonna say you saw it where?
This window?
Okay. The driver's side window, you saw the gun?
Yes.
Okay. And so he rolled down, the window was down, obviously, correct? And, what did that car look like?
I don't know the model of it, but it was black. I want to say it's a Chevy, a black Chevy.
A Chevrolet, I'm sorry?
I want to say, it's black for sure, but I want to say it's a Chevy.
Was it a sedan, SUV, something else?
Let's see.
SUV. And, you said you saw the gun, from the other vehicle. Did you see what it looked like?
No,
You indicated, during the direct exam that after the shots were completed firing, you saw Mr. Jackson and Mr. Davis run back towards the house.
yes,
Okay. And, when you say that, you were sitting in the SUV, correct? You were
yes,
still in the car,
yes,
and you were in the back seat,
yes,
and you were facing forward towards the street, right?
yes,
The vehicle had backed into the driveway, so you were facing that other car, basically.
yes,
Okay. And, when you say back towards the house, so you observed, Mr. Davison and Mr. Jackson moving back behind you? Did you turn around and see where they went?
Well, after the shooting happened, I did turn around, but before I turned around, I opened the door to check in the front to see if I could see them anywhere, then I turned around.
Okay. But then they went back towards the house and then you didn't see them after that? You were asked about a statement that you made to the police, during direct exam. I wanna, bring your attention to that. When you spoke to the police about this case, right?
Yes,
And, you were questioned by, a Detective Lehman, correct?
yes,
And you were questioned for several hours, correct?
yes,
And this took place, the questioning took place, it was after midnight, correct?
yes,
If you recall. This incident happened, I guess, this incident happened like a few hours before that questioning started, is that correct?
yes,
Okay, and so it was late in the night when you were being questioned.
yes,
And, you were trying, to be helpful, correct?
yes,
And trying to tell the police the truth, correct, about what happened?
Yeah.
Okay. And, you knew that, Mr. Davison that he was untethered to the court, correct?
Yes,
And you knew that he wasn't supposed to have a gun.
yes,
And that's why you said that he was handed the gun, correct?
yes.
But your testimony today was that you never saw anybody hand anybody the gun. And so, who was untethered? Mr. Davidson. Okay. Is that what I said?
Yeah.
Trying to-
No, I really didn't, I didn't hear.
Okay.
Thank you.
And the statement that the prosecutor showed you today, that's not your handwriting, correct?
No.
And that's a 3-page statement, correct?
Yes.
Okay. You signed the bottom, because the detective asked you to do that, right?
Yes.
And you dated it and put the time on it. And you were worried, you have kids, right? You were worried, about being held in connection with this in some way
Yes.
when you were speaking with the detective. You were scared. After this incident, Mr. Jackson, you found out at some point that he had been shot, correct?
Yes.
And you went with him to the hospital.
Yes.
And while you were at the hospital, did you speak with any police officers?
No, besides the detective other than that,
When you did the detective, you just meet Detective Leyland?
that's the only person I spoke to.
Okay, did you see any other officers?
No.
You never saw Mr. Jackson shoot a gun on this day, right?
No.
When you were in the hospital with Mr. Jackson, he was handcuffed to the hospital bed, correct?
Yes.
And that was the whole time that you saw him there, he was handcuffed to the hospital bed?
Objection relevance.
I mean, I can move on.
I'd ask that be stricken for the record.
Seeing that there's no relevance stated, I will strike it.
Well, Your Honor, Mr. Jackson does give a statement. I'm not really contesting the voluntariness of that statement today, but I think it is relevant to the case.
I would object that it's relevant to the case in general or relevant to what this witness is testifying.
She's testifying to her observations on this day related to this case.
Well, seeing that she said the voluntary of the statement, I will allow it. Seeing that will be, we talked about a statement that's going to be placed on the record by the YC, right?
I'm not even sure I'm still going to judge.
Okay. Well.
But it was, I will state that on the record that that was my initial intention.
I'm still gonna allow it, but I don't think we need to bring things forward anymore
I don't think it's good.
with this witness.
Okay, I don't have any more questions for this witness.
Okay, so you testified, when you heard the shots, you ducked down in the car, correct?
Yes.
You're in the back seat of the car?
Yes.
All right. Did you duck down because the shots were incoming?
Yes.
All right, so it's your testimony that the other guy, the guy in the other car, crossed the way. He was the one that started shooting first.
Yeah.
All right. Tell me about when the detectives, when the police interviewed you, did you feel intimidated? Did you feel threatened?
I felt nervous. I've never been through it before, but I don't feel that if I don't have much answers to give, I shouldn't have to go to jail for anything. I'll be threatened about anything at all.
All right. How many kids do you have?
I have
Objection
one.
relevance.
I'm gonna then ask her if she felt intimidated that CPS was gonna come and take her kids from her.
Okay, so it was asked by Attorney Phelps about her having children.
I must have not heard it,
Yeah,
so
she did ask about that on cross.
in that case, I'm gonna have to withdraw, I understand that, okay.
How many kids again?
One,
Alright. Were you worried you didn't cooperate with the police? CPS was gonna come and take that kid from you?
yes,
Alright, nothing further.
Redirect. In the same vein, these are your friends and your family, aren't they? The defendants in India, India's family and Keontae and Jordan are friends,
Your Honor,
right?
I'm gonna object to asking the answer. She asked us at the beginning of her direct. I think we need to go back.
Well, I think I should be able to go through it again. We have now allowed defense to ask this witness about whether or not she felt intimidated by the police. I think it's fair to ask whether or not she feels intimidated to give the truth, given her relationship with these individuals.
That's fine, I'm gonna allow it, just to get to the next part of the question.
Sure. Is it fair to say you don't actually want to be here testifying?
I don't,
Okay. And is it fair that you are concerned about the safety of the two defendants seated here today? Okay. And isn't it also true that in your statement, you never actually say who shot first because you didn't know who shot first?
I don't know who shot first.
Okay, thank you. In fact, isn't it true that you were looking down at the time that you started hearing shots?
Yes,
All right. And isn't it also true that in your statement, you stated that Keontae carries that gun with him when he goes into different areas where he doesn't feel safe?
yes,
Okay. And is it also true that in your statement, you said,
Your Honor, I'm gonna object to this as, first of all, leading, and second of all, way beyond the scope of redirect, excuse me, and the scope of cross-exam, everything that we've covered already here, Judge. And, yeah, I'll leave it at that was objection.
well, Your Honor, I'm going to state that as given that I was impeaching this witness and I continue to impeach the witness, I can now leave. That is allowable once you're impeaching a witness.
And again, Judge, it is beyond the scope.
Well, I would say it's not a beyond the scope, given that we have a question of bias. And therefore, the people were raising the issue of bias and clarifying statements that were made on the record that would clarify any issues of bias and her testimony as to what it was then versus what it is today.
And Your Honor, she had an opportunity to do that during direct. It's not the proper scope of her redirect.
Okay, it started off, she was basing her questions off of cross, but once plaintiff witness stated that she did not know who shot first, then she is opening or asking her questions and teaching her, which now goes to her credibility as a witness. So I'm going to allow it based off of her statements that are contradictory at this point.
Your Honor, I would just renew my objection, Judge, to be honest.
Okay.
I have nothing further, Judge. Thank you.
All right, any questions based off of redirect?
No, Judge, nothing further. Okay.
Ms. Lewis?
yes.
You can sit down and have a seat. Now. Okay, we're gonna take a quick 5-minute bathroom break.
5
I
minutes.
agree.
Okay.
Yes, sir.
You're back on the record. It's the people of the state of Michigan versus Jordan and Manuel Davis. This is defendant number 1, Nancy Jackson, defendant number 2, case number 2261042. We took a recess, and we are back on the record for the next witness. Whenever you're ready.
Ready. At this time, Your Honor, we're going to call Officer Aquan Moore.
Recorder and I'll straight it. Make sure you speak up in the microphone.
Okay.
Whenever you're ready.
Judge, I do want to place on the record before we move on with this witness that the people will not be calling on Ms. India Jordan at this time. And therefore, Ms. Robinson will no longer be needed either.
India Davis?
I'm sorry, India.
Okay. Okay, Attorney Robinson, did you hear that? Well, if you can hear us, Attorney Robinson, you are no longer needed. APA session is not going to call Ms. Davis.
It's actually, I'm sorry, Judge, it was India Jordan.
It is?
Yes.
Okay. I'm sorry. India Davis.
Thank you, Judge. Okay, Officer Moore, can you please give us your name, your full name for the record?
Yes, ma'am. My name is Equan Moore.
Thank you, sir. And how are you employed?
I'm a Detroit police officer for the 6th precinct.
Thank you. And were you employed as a Detroit police officer for the 6th precinct on December 19, 2022?
Yes, ma'am.
Were you working in capacity as an officer on that day?
Yes, ma'am.
Were you called to a location of 7286 Penrod in the city of Detroit, County of Wayne?
Yes, ma'am.
What was your purpose of going to that location, sir?
It was a shots fired run.
All right.
My partner and I made the location. There was another unit that had a gunshot wound.
Objection, Your Honor, hearsay. Which part were you saying about this other unit? It doesn't sound like you have personal knowledge of that.
Well, I don't think that's even been established whether or not he has personal knowledge of that.
Okay, you said that there was shots fired run,
Yes,
and
ma'am.
then another unit.
Yes,
That's
ma'am.
all you said, correct?
There were 2 runs that were in conjunction with our run.
Okay.
All right, and you say you worked with a partner?
Yes, ma'am.
What was the name of your partner on that day?
My partner that night was Terrence Allen.
All right, and were there other officers already on the scene when you arrived?
My partner and I were the first officers who was saying that.
Okay, and then other officers appeared?
Yes, ma'am.
All right, and when you arrived on the scene, did you attempt to locate any weapons?
When we first arrived to the scene, we canvassed the area to see what was going on.
Okay,
Upon our findings, there were bullet casings,
all right.
and
Let me stop you there. Where were those bullet casings found?
there were bullet casings in the street.
Your Honor, I'm just gonna object this to personal knowledge here, if you can make it clear, what his observations were and not what the, he recovered and all of those things. It's really not clear to me, but where his basis for this testimony is.
I believe he stated that he canvassed the area and found bullet casings with his
Right.
partner.
Right, with his partner, so it's just not clear, if we can just stick to his observations. The way that he's phrasing it is making it very unclear whether or not he's talking about what he did, or if somebody else told him that they recovered things, if we can just make the record clear.
Well, I think he stated that he observed bullet casings or found bullet casings. So I will clarify though, Judge?
And moving forward, to make sure you testify to what you saw, and if your partner was with you, you can testify as well,
Yes, ma'am.
if your partner was with you, or any other officer.
Yes, ma'am.
Okay, so when you were working with your partner, did you find bullet casings?
Yes, I did find bullet casings.
All right, then where were those bullet casings found?
There were bullet casings found in the middle of the street
Okay,
as well as the front yard of the rental.
of the run location?
Yes, ma'am.
And would that be the 7286 Penrod Street?
Yes, ma'am.
All right, did those bullet casings appear to be from the same make and model? Let me start that. Were the bullet casings found in the middle of the street appear to be the same casings found?
Your Honor, I'm gonna object to this as leading.
How's that leading? It's whether or not he recognized whether or not they were the same.
You're suggesting the answer that these were the same. You can ask, if, what the different
is
types
leading.
were.
You just rephrased it as far as finding casings in the street and the front yard.
I can, Your Honor, but a yes or no question is not, it doesn't assume the answer.
It's suggesting the answer.
And did you find, so you found bullet casings in the middle of the road
Yes, ma'am.
and you found bullet casings on,
Your Honor, again, she's receiving this testimony, but this is leading.
It's because of the objection, she's trying to finish her questioning on whether or not these bullets were the same bullets.
correct. Thank you, Judge. May I proceed?
Yes.
All right. The bullet casings that you found in the driveway and the bullet casings you found in the middle of the road, did they appear to be of a similar caliber?
Your Honor, again, this is the same question that she's asking, which is leading and suggesting the question, suggesting the answer. She can ask, what type of caliber casing was found here? What type was found there? And then it wouldn't be leading. The way she's asking it, number one, it's a compound question, and it certainly is leading.
Compound, how?
She's asking about she's asking about the way that it's compounded, that she's asking two different facts in one question, right? So she's saying the bullet casings found here and the bullet casings found here, they were like the same, that you thought it was like that. Like,
No,
it's just not.
that's a misrepresentation of what I asked, completely, and it's not a compound question, but I'm going to take great umbrage in a complete mischaracterization of the question I have asked.
It's not compound, it's just two different sites, she's asking if the bullets are the same.
And again, Your Honor, I would renew my objection that it's leading.
I
You can ask the question.
do you recall what kind of caliber or what type of casings you found on the driveway?
To be specific,
Yes.
the caliber, no. But based on my experience on the job, I know there were two different guns based on the casings. One was specifically from a handgun and the other was from an assault rifle. Yes.
All right. And when you canvassed the area, did you make any other findings?
Upon the first arrival, no ma'am.
Okay. Did you make a second arrival?
Yes, I did make a second arrival, yes ma'am.
Okay, when you say you made a second arrival, what does that mean? Help me understand what you're talking about.
The first time I made that location with my partner, we did canvass the area and we found bullet casings. Upon investigation further, there were other things that we had to leave the location to go get, as in a vehicle that was also towed. It was towed by Bobby's Towing to
Okay.
our Mount Elliott tow line.
All right.
The second time my partner and I made the location, I received a call from Detective Lehman
Okay.
that advised that.
Objection, hearsay.
That's fine. Based on your phone call with Detective Lehman, did you go do something?
Yes, ma'am.
What did you do?
I made the location where canvassing again, I went into the backyard. Behind the back of the house was an assault rifle.
Okay.
The assault rifle was buried under the leaves between the brick wall and the carpet.
All right. And was this location the 7286 Penrod location?
Yes, ma'am.
All right. And you say it was an assault rifle?
Yes, ma'am.
Did that assault rifle appear to match the casings you found in the driveway of that location?
Based on my experience and knowledge on guns, I couldn't say so, but based on the area, yes, ma'am.
Thank you. Nothing further.
I'm sorry, but she said, based on my training experience, no, and based on the area, yes, I'm gonna object to speculation, and I don't understand.
For us.
Well, I would still object to that coming in as speculation and ask for it to be stricken. Because he said no, and then he said yes.
Well, it's based on his training and experience. It's an answer. If defense counsel wants to, can ask further questions on fraud.
Yeah, please, because I said based off of, I'm not actually sure what that means either, so.
But you're right, I would just would move to striking as speculation.
What's about speculative?
He said based on his training and experience, they didn't match, no, but then because of the area, yes.
Oh, that's the follow-up.
Okay.
Can you explain what does that mean, sir?
Yes, ma'am, I can definitely explain what that means. So specifically, I know the caliber of if we say 9mm, or any handgun casing, because they do not match the same as a bullet or a casing that would come out of an assault rifle.
Okay,
When I recovered the weapon, my partner cleared the weapon.
okay. Did you observe your partner clear the weapon?
Yes, ma'am.
All right, and he was clearing that in front of you, sir?
Yes, ma'am.
Okay,
And when that bullet, when the weapon was cleared, there was a bullet in the chamber. That bullet matches the casings that were recovered. Yes, ma'am.
and did those match the casings that were covered in the driveway of that location?
It was more so the front yard, not the driveway. Yes, ma'am.
Okay, thank you. Thank you for that clarification. Much appreciated. Nothing further.
Good afternoon, Officer Moore. I'm just gonna ask you a couple of questions, okay? If you don't understand my question, will you ask me to rephrase?
Yes, ma'am.
Okay. So you indicated that, you arrived on the scene initially, the first time, right? That's at 7286 Penrod, right?
Yes, ma'am.
And, you indicated that you canvassed the area.
Yes, ma'am.
And when you say you canvassed the area, where did you canvass?
Specifically, we canvassed in front of the house. We canvassed the street. We canvassed down the street and knocked on doors to see if any neighbors heard it.
And is it your testimony that you did not canvass the backyard?
Upon the first arrival, no, ma'am, I did not.
Okay, and your testimony is that you were called somewhere else?
Yes, ma'am.
Okay, and, when you were called somewhere else, were there other officers on the scene still?
Officers stood by for evidence tech to make the location. Evidence tech specifically to recover the shell casings that were outside.
Do you know which officer stood by?
I don't remember. I don't recall.
Okay. And when you returned, were there any officers on the scene?
No, ma'am.
And you indicated that this, weapon was found in the backyard, correct?
Yes, ma'am.
And, it was found, I'm not gonna go over your testimony again, but you said that it was found against the house, correct?
Yes,
The
ma'am.
brick of the
Back of the
house. And that's from the house being 7286 Penrod, correct?
Yes, ma'am.
Okay. Do you recall how many shell casings were found in the road?
Not completely. I don't recall that.
Okay. And you were the one who recovered those?
Did I recover the casings?
Yeah.
No, I discovered the casings. I didn't
Oh,
recover
okay.
them.
And then
Evidence
somebody
tech
came and
recovered.
Understood. And then, you were the one who discovered the casings in the grass?
Yes, ma'am.
And where were those found exactly by you?
They were in the grass. They were in the front walkway. They were on the porch.
Okay. On the porch of the house.
Yes, ma'am.
When you say the front walkway,
The walkway leading to the steps of,
okay. And when you say in the grass, can you tell me where in the grass? You said in front of the house?
yes, ma'am.
Okay. And did you find any next to the house?
No, ma'am, I don't recall any cases next to that.
Did you, you indicated you went to another location, was that a gas station?
No, ma'am.
Okay, what was the other location?
I don't recall the numbers by heart, but it was Mansfield Street where we recovered I don't recall the vehicle by heart, but we did recover a vehicle that was in conjunction with the one.
Okay, and that vehicle, You don't recall what kind of vehicle that was?
No, ma'am.
Would it refresh your recollection to review your partner's report from this day?
Yes, ma'am.
Look at that, and then let me know when you're finished. Has your recollection been refreshed?
As far as the vehicle, yes, ma'am.
Okay, and that was a Ford Explorer, correct?
Yes, ma'am.
Okay, and, did you make observations of that vehicle?
I did observe the vehicle, yes, ma'am.
Okay, and did you observe, any shots in that vehicle?
No, ma'am, not the white Explorer, no, ma'am.
Okay. Did you observe the, tire being blown out?
No, ma'am.
Okay. I don't have any further questions, thank you.
So officer, tell me about the shell casings in the street that you found, or you discovered them, correct?
Yes, ma'am. I'm not,
Sir.
correction, yes, sir.
All right, I have to check with somebody else about my pronouns, but it's sir, yeah, I think it's,
My fault.
that's all right, that's all right. So anyhow, the ones in the road, where'd you find them? I mean, were they in one group, two groups, three groups, all together, spread out?
If I recall by heart, the casings in the road were closer. The casings that were in the grass, front yard, and walkway of the house, they were more spread.
All right, that's fair. All right, and I know you're not a ballistics expert, but you've got experience. So the ones in the road, what kind of gun do you think that came from?
The ones in
The street, the ones in the street.
the street,
Yeah,
my experience, a handgun.
all right, all right, all right. And you got, I know Attorney Phelps just showed you the report, but if I could get it from her again and show it to you, you weren't sure how many casings you found in the street. You think the report might help refresh your recollection?
I'm not 100% sure, but.
All right, well, we'll show it to you. We'll show it to you. Maybe it's up there. Yeah. Yeah, I'll bring it. All right, just take a look through it. Maybe that'll help you say how many. Any help after reading that over?
No, sir.
All right. Um, the ones in the road, any indication with your experience if they came from two different weapons or the same weapon?
No, sir. I'm aware how many weapons it came from.
Okay, you're not qualified to say that. Correct, you're not qualified to say that.
No, sir.
Okay, fair enough. Thank you.
I just want to get a clarification. You stated that the weapon you located was like an assault rifle.
Yes, ma'am.
Can you describe that for us?
The assault rifle specifically?
Yes.
It was a black assault rifle. It had a scope. I don't know the scope specifically, but it had a scope attached to the top of it. The trigger, well, the safe on the weapon was still on, so it wasn't safe. And upon me, once I acknowledged it and it wasn't safe, that's when I gave it to my partner.
Okay, thank you. Nothing further, okay. Work off this, down. No further witnesses, Your Honor. The people at this time are going to move to bind over on all counts. I ask that this court find that there is a question of fact for a trier of fact and bind over this both defendants on all charges, find that there is probable cause to believe that these defendants are the ones who have committed these offenses that they are charged with, assault with intent to murder. I ask that this court find that the defendants, there is testimony that Mr. Tipton stated that he observed a light colored Ford Explorer that was in front of the house across the way it's parked parallel to the houses across the way, then backed into the house across the street. That he observed who we described as the big dude, that being Mr. Jackson, questioning him as to why he was there, as well as observing the light-skinned man that we have now identified as Mr. Davison, who then also shot. But we have him stating that upon being questioned by defendant Jackson and saying that he doesn't have to tell him who he is or why he's there, that Mr. Jackson then says, all right, and then Mr. Davison begins shooting. The weapon described was a longer weapon, longer than a handgun, that he described as a type of an assault rifle type weapon. We have by Ms. Chanel Lewis, just the gun described as having a banana clip, an assault rifle style weapon, and having a scope. When the officer just testified, Officer Moore just testified, he stated it was an assault rifle, a gun, and the gun in fact did have a scope. Chanel Lewis also testified that she observed the defendants go behind the house, that the defendant Davison had the weapon at the time, and then when both defendants returned the gun, neither of them had the gun anymore. She also testified that Keontae Jackson gave the gun to Davison to use, and thus assisted in this assault with intent to murder, as well as assault with intent to do great bodily harm, as well as the felonious assault and the corresponding felonious assault. We have Ms. Chanel Lewis testifying and again identifying who is who in this courtroom and who was driving the vehicle, being Keontae Jackson, who had the gun next to him in the driver's side seat, who did admit to having stated that in her statement she indicated that he does carry that gun around when he feels unsafe. That same gun that he instructed Davison to take and use, and who then did use and shoot at the complaining witnesses, Mr. Tipton and Terrell Gibbons, who was also seated in the vehicle next to him. So for all these reasons, Your Honor, we ask that this court find that there is a question of fact.
Your Honor, as to Mr. Jackson, I would object to the bind over on all of the charges and move for dismissal at this time. The people's theory in this case, it does sound to me, is a theory of aiding and abetting, which requires them to show by probable cause in order to get the bind over that an alleged crime was actually committed either by the defendant or someone else. Before or during the crime, the defendant did something to assist in the commission of the crime. At that time, the defendant must have intended the commission of the crime alleged, or must have known that the other person intended its commission, or that the crime alleged was a natural and probable consequence of the commission of the crime. Your Honor, as to Mr. Sessian's arguments here today, there just is not enough to bind over Mr. Jackson on these counts, even under an aiding and abetting theory. Again, in order for them to bind over, they have to show that Mr. Jackson must have intended the commission of a crime or knew that the other person intended the crime and aided him in that. And here we have testimony, even if we believe
So we heard some testimony from Ms. Lewis. We heard first some testimony that she didn't hear anybody say anything, she didn't see a gun handed to anybody. And then we heard that she was interrogated by the police for hours, that she was intimidated and scared, and that she signed a statement written in the hand of the detective's handwriting that said that she saw Mr. Jackson hand the gun to Mr. Davison and said, in case anything happens. And Your Honor, I think that alone, even if you believe that part of her testimony today, even if you believe that, that is not enough to show aiding and abetting for all of the different charges that Mr. Jackson is charged with here today. He, again, indicating in case anything happens, is indicating that it would be used in self-defense. I don't think that you can extrapolate anything more from that. You certainly cannot infer an intent to commit a crime here. You also heard testimony from Ms. Lewis that she thought that the driver of the other vehicle was shooting first. She did indicate later she didn't know, but she thought the other driver started the shoot, which again would negate any sort of crime being happening here, let alone the fact that Mr. Jackson certainly didn't intend for there to be the commission of any crime. You heard testimony that Mr. Davison, when he was shooting, he was by the house, not by Mr. Jackson. You heard testimony from Mr. Tipton that he had a conversation with Mr. Jackson. He said, as Ms. Narcessian put in her argument, he said, you know, I don't have to tell you why I'm here. Mr. Jackson says, all right, if you are believing all of that testimony. But again, he says, all right, and then shooting happens. It doesn't say that there was no testimony that Mr. Davison came up and could hear the conversation between these individuals. It sounds like again, the testimony was that he was in the lawn between the houses when that conversation was happening, while Mr. Jackson was in front of his vehicle talking to another person in the road. Again, Your Honor, there just isn't enough here to link Mr. Jackson to these crimes and to show that he intended the commission of a crime. And Your Honor, I mean, there was testimony about the two running to the back of the yard after the shooting stopped, but again, that alone is not enough. You can look at the jury instruction for accessory after the fact. That might be, you know, that's again a different charge, and that is not enough for aiding and abetting to bind over on all of these charges. And Your Honor, we know that mere presence is insufficient to bind over on an aiding and abetting theory, even if, and that, you know, we have a jury instruction on that just says even if the defendant knew that the alleged crime was planned or was being committed, the mere fact that he was present was not, when it was committed is not enough that he to prove that he assisted. Again, Your Honor, there just is not enough here, even if you take everything that was said here today at face value and believe the testimony that the prosecution wants you to focus on here. Again, it is not enough. Handing someone a gun and saying, in case something happens, which again, we have testimony that actually isn't what happened, and that Ms. Lewis was pressured into saying that. But Your Honor,
No, sorry, I'm gonna object. You can't say that Ms. Lewis was pressured into saying that. There was no, I mean, to say, is she insinuating that I pressured her into saying that?
Your Honor, I'm just characterizing, I guess, the evidence that we heard, the testimony that we heard about her being. Okay, then I'm sorry, I'll just do a longer version. We heard testimony.
Sorry, I'm gonna ask that it be stricken from the record.
Well, I don't think she was pressured. I think she gave two different accounts.
Right.
Of who was questioning her.
Right.
So I don't think anyone today pressured her. I mean, I think alone she does not feel comfortable being here.
Right.
Or did feel comfortable being here. I will strike unless you have some testimony or any party can say that she was pressured today to say what she said.
No, I didn't mean that, Your Honor. I meant the statement that she had written out that was brought in to impeach her today.
She did say that she felt
Pressure. I'm sorry. My argument was.
She said she felt intimidated and scared or intimidated.
Your Honor, I'll strike it. It's really not the
very
crux of my
intimidated during
argument.
the investigation. Those are the exact words.
I'm sorry.
Very intimidated during the investigation.
Thank you, Judge. But again, I mean, that's not even the crux of my argument. I'm saying here, even if you take the part of the statement that the people want you to believe, it still isn't enough to bind over on an aiding and abetting theory, assault with intent to murder, assault with intent to do great bodily harm less than murder, felony firearm, felonious assault, all the different counts of felony firearm. Judge, again, they have not presented enough to bind over Mr. Jackson on these counts.
Judge, may I address this defendant first before we move on to the second defendant? Your Honor, what I find very interesting is that prior to it being inferred by the defense that she was intimidated by the investigation, as she stated, the witness, it did indicate that it was quote unquote fresh on her mind at the time of making her statement. So I think that that is what's very key here. At the time of making her statement, she does not indicate, she admitted she did not indicate who shot first and she did not know who shot first. I think it's very important that she also stated and admitted to stating that Keontae is a paranoid individual. I don't know what was going on in that street or what he has going on that street.
You know, I don't think this part of the statement made it into the record earlier. There were objections around this part of the statement. I could be mistaken, but I don't believe this part is.
I know I did ask her, isn't it true that you say that Keontae is a paranoid individual?
I think the objection was louder over your question. I didn't even hear it.
Okay.
But in Your Honor, then you did sustain the objection, and then it was stricken.
I didn't even hear that question.
Okay.
I'm sorry, I didn't hear it.
All right.
I heard the objection, and what was my response? I don't have a play-by-play exactly what the response of the attorney felt. What was your objection?
The objection, it was, these questions were being asked about this statement during one of the redirects, and it was outside the scope. I don't remember exactly this part of the statement, I do not believe came into that.
Well, if you asked the question, you asked it.
I did ask it. Yes, I did ask it. I think it's very clear that this witness was nervous to be here. She indicated she was nervous to be here. But what was important to note is that she admitted that the events of the time were fresh in her memory at the time of making the statement. And that it was only until defense counsel placed in her mind that she was intimidated during the time of the investigation. So I'm asking the court to consider the testimony that was relayed upon impeachment. And I'm asking the court to also consider the corroborating testimony and evidence as to where the gun was located, what type of gun was utilized, and where the gun was, and thus infer that the testimony about Keontae having that gun in the vehicle next to him when he was driving and having given it to his co-defendant, Mr. Davison, coincides with the reality and the truth of the matter as it was fresh in her mind when she gave that statement.
Judge, I'm going to limit my argument on the attempted murder charge. What I found interesting today was the testimony by the first individual, the complainant. I basically was trying to find out who shot first. Was it simultaneous? He indicated that everything happened fast, but then I asked him to take his time and really answer. What we learned from his testimony today was that he believed he was shot through the car panel in his leg, and then he returned fire. Well, I can't place that in my mind with the testimony from the female who says she's ducking down in the car. And I asked her why she's ducking down. Are these rounds incoming? And she says, yes, people were shooting at them. So how is the complainant able to have the composure to be shot in the leg, then find his weapon, which he said he didn't brandish, to the big guy who came up to him, and then somehow have the ability to shoot the big guy? We know the big guy got injured. I can solve this whole rubrics very easily. The first witness, the complainant, he shot first. That's how it went down. That's the only way it makes sense. So I asked you to throw out the attempted murder charge. I'll leave my argument just to that kind.
And Your Honor, I asked the court to consider the fact that defense didn't ask that question about how did you shoot after being shot in your leg. And
The
he
court
is
can infer that.
well, then the court can also infer that adrenaline was rushing through this individual at the time, which does lead individuals to be able to defend themselves after being injured.
I will start with Mr. Jackson first. As Attorney Phelps read jury instructions, the record, I will go through both of them again for the aiding and abetting period. It states that the charge prosecutor must prove each of the following elements in this case, not beyond reasonable doubt, but it's probable cause standard. One, that the alleged crime was actually committed either by the defendant or someone else. That's not a question here. Second, that before or during the crime, the defendant did something to assist in the commission of the crime. That is what I'm going to focus on. Third, at the time, the defendant must have intended the commission of the crime alleged, or must have known that the other person intended its commission, or that the crime alleged was a natural and probable consequence of the commission of the crime. So the issue is here for me, for the court, with the second element, that before or during the crime, the defendant did something to assist in the commission of the crime. We have testimony, the court heard that from young lady in the vehicle, Miss Lewis, that there was a weapon she described as longer gun, black, not a handgun, that was in between seats between the driver and passenger. And she also testified that, well, Keontae gave the gun to Ice, Ice being Mr. Davidson, in case anything happened. I don't find anything else in the testimony from any of the witnesses that shows that Mr. Jackson actually aided and abetted in the act of shooting at the complaining witness. That would be Mr. Tippett. He very well may have been involved as far as in conjunction with Mr. Davidson. However, the testimony is only from Ms. Lewis stating those two things. And Attorney Phelps did bring up another good point. Even if I were to consider accessory after the fact, this testimony that the complaining witness, Mr. Tipton, shot back. So any reasonable person, they're being shot at would run. And I don't think that I consider that they ran in the same direction as being in unison of a crime when dodging bullets and also Mr. Jackson actually being shot. I think for Mr. Davidson, the people have met his burden of proof for count 1, 2, 3, 4, 5, 15, and 16. But I do also believe that there'd be a question of the trier factor, whether who shot first, whether Mr. Tipton had the ability to shoot back after he testified that he was shot in both legs and then in the back. But as far as Mr. Jackson, I do not believe there was testimony presented today. Mr. Jackson, you have something?
I do, Judge, because I'm asked, is the court also still considering though, and in my argument, I did make it in my argument,
Yes.
that upon Mr. Jackson saying, all right, that's exactly when his co-defendant begins shooting. It appears that that was like a signal for him to begin shooting. If exactly upon him saying, all right, that's when the co-defendant begins shooting. At the very least, Your Honor, that is a question of fact of what was exactly transpiring. It appears that upon saying, all right, and then shots start firing, that this was the signal.
Your Honor,
Go ahead.
just to briefly reply, I did cover this in my argument already. But there isn't testimony that it was exactly right after that, right? He said, the person said, all right, there was shooting after that. And then there's also testimony that they weren't close to each other. I mean, you can't, that she's just asking you to go too far to infer that there was some kind of signal established, but there's nothing on the record to reflect that.
I have from Mr. Tipton that the defendant to Mr. Jackson said, who y'all sitting here for? He said again, who the fuck y'all sitting here for? Complaining witness said, fuck you, no response. And then Mr. Jackson said, all right, and defendant one started shooting. I think it's a reach to say that Mr. Jackson signaled or said or directed Mr. Davidson to shoot based off of saying, all right. I don't think that that's even as a probable cause standard to draw the connection that they were in unison. Mr. Davidson could very well make his own mind up as to whether he's going to shoot or not. And Mr. Jackson said, all right, he doesn't say, all right, we'll take care of him. I don't think there's enough here to draw the connection for element 2 saying that before doing the crime, the defendant did something to assist in the commission. So I'm going to bind over Mr. Davidson on the counts that I just read, and for Mr. Jackson, I am going to dismiss without prejudice his counts based off of insufficient evidence.
One last request for Mr. Davidson of pretrial services, bond over you.
I will order that in file.
Thank you.
Your Honor, and if I'm gonna indicate on here that he is untethered so that can be removed for Mr. Jackson today. And I would just request for it to be dismissed with prejudice. I guess, I don't know.
There's nothing in law that will allow this to be a dismissal with prejudice.
I mean,
You tried. Yeah, no, it's without prejudice.
It's really unprofessional to try when it's not valid.
Judge, just to clarify, Jordan Davison, he's bound over on all charges, correct?
On the charges, yes, that, all of his charges, correct.
Yeah, that's what we thought. No.
I got you.
Oh, okay, thank you, sorry. We have to go back on the record. AOI date for Mr. Davidson. Mr. Davidson, your attorney has stepped out in the hallway. I will let him know the date as well, but you're waiting on the information. It's 1 week from today. It will be March 13th at 9:00 a.m. Frankfurt College. Okay.
he's gone, Judge.
Okay. I did place on the record.
Thursday we got, I mean, I'm sure.
Thank you, Judge. Have a good day. I'll see you Thursday. Today is Monday.
Monday.
Yes.